Hello everyone, welcome back to our channel. This session is going to be on the self-paced online modules Set A Corporate and Economic Laws, and in that particular subject also we are going to take the Foreign Contribution and Regulation Act 2010. So this is the agenda for this session. Already we have uploaded a lot of videos. For Set C arbitration we have uploaded, for Set D entrepreneurship we have uploaded the marathon sessions, and then for Set B costing also we have uploaded a 24-hour session which is based on the practical sums 12 hours and then theory 12 hours, and we have uploaded the repeated questions videos, everything also. This has gained a lot of support from you people. I am genuinely thankful for that, and I hope forward that you will support for this kind of CTA sessions also. So I would like to place a request to you that you have to give the same support which you gave for set B, set C, set D. I would like to get the same support for set A also. So like this video, share this to your friends, and comment what are your thoughts on this video, like what is the next chapter that you want, or what are the suggestions, or what are all the things that you need to know. If you have any doubts in this topic also, you can put it on the comments. I will try to clarify that. So that will be the thing. You can like this video, share this to your friends, and do the comment. So that will be helpful for me. So I hope you will all support this, and we can start the session. Now we are going to see the Foreign Contribution Regulation Act. This will come under the economic laws. In the subject of city, it will come under the economic laws. And when you see this particular law, we can start the discussion for the Foreign Contribution Regulation Act 2010. Here, when you see the title of the law itself, it is Foreign Contribution Regulation Act. So we need to know the meaning of foreign contribution. What is the meaning of foreign contribution? Regulation Act means we are going to regulate the foreign contribution. So what is the meaning of regulation? We are having two types of act. One is the regulation, another one is the management. When you see regulation, there will be a lot of compliance. We have to file this annual return, get this permission, this you should not do. When you do this, you have to get the permission. Then like that, we are having a lot of compliance and all, and there will be less freedom for the people who are under this act. But when you see the management act, we will have more freedom. When compared to the regulation act, we will have more freedom. Up to this limit, no need to get any permission. And when you do this transaction, no need to get any permission. And only one list is there, negative list. That alone you should not do. Otherwise, whatever transaction you want, that and all you can do. Like that, we are having more freedom in the Management Act. So that is the difference between Regulation Act and the Management Act. This is the Regulation Act. This means that we will have a lot of compliance. This will be more strict. And then less freedom will be there for the people under this act. So now we have seen an introduction of this particular act. Now we have to see what is the foreign contribution. In short, if I want to tell you, foreign contribution means whatever the amount you are getting from a foreign source. You are a person resident in India or you are in India. You are going to get some amount from foreign source. So that will be called as a foreign contribution. For getting this amount in return, you are not doing anything. So that is the meaning of foreign contribution. You are getting something for free or for some other purpose. You are not going to give any goods or services outside India. So that is not there. So in simple meaning, from foreign source you are getting some amount, you are in India, in return you are not doing anything. That is the foreign contribution. Now we can see the definition, actual definition of the foreign contribution. Now we can see the definition for the foreign contribution. Here when you see foreign contribution, it means the donation, delivery or transfer made by any foreign source. So from a foreign source you are getting the donation, delivery or transfer. Donation means you are getting it, delivery means they are going to give it to you, transfer means they are transferring it. Those are all simple words only, nothing to explain there. They are donating, delivering or transferring. The foreign source is doing that. What they are donating, what they are delivering? They are delivering the article, currency or security. What is the meaning of article? Any object, any particular thing that they are giving it to you. Then currency, any currency, Indian currency, foreign currency, that they are giving it to you. Security, security means bonds, debentures, equity shares, everything will be coming under the security. It will be defined in the Securities Contract Regulation Act. So we have to go to that act and see that. So that much is not required for now. We can see that security, any security, even if they deliver that, it will be coming under the foreign contribution. For this, we have taken a lot of things. Article, currency, security, everything we have included. Now we have to see some things. Some exceptions we are having. It is in the form of explanations. Any donation, delivery, transfer of an article, currency or security by any person who has received it from a foreign source. So here we can see one example for that. So foreign source is there. From foreign source, one person in India, he is getting some amount. That is a foreign contribution, no doubt on that. Because directly from the foreign source, he is getting the amount. So that is foreign contribution. Then this person, that particular amount he got, that amount he is transferring to another person. When he is transferring to another person the same amount, that is also foreign contribution. So this is the explanation number one. When you are directly getting from foreign source, that is foreign contribution. When you are sending that foreign contribution to another person, that is also foreign contribution. Then the next explanation we can directly see from example itself. We are having one foreign source. That foreign source is giving to a person in India some foreign contribution, some article, currency or security it is giving. Foreign source is giving to a person one. Now this person one, what he is doing? He is depositing that amount in a bank. Then he is getting interest. Whether this interest is foreign contribution or not, that is also foreign contribution. So principal amount you are depositing, that is also foreign contribution. The interest you are getting, that is also foreign contribution. So for both the amount, all the relevant complaints in this act will apply. Then third one we can see, you are getting some fees from a foreign source, like a foreign student is there, he is going to come and study in an Indian educational institution. Now, that Indian educational institution is collecting some fees. That is also from foreign student only you are getting. So, that is a foreign source only. So, just for now, you can understand that anything from outside India, it is foreign source. So, that fees you are collecting, that will also come under the foreign contribution. When you see the definition like this, any currency when you are getting, it will come under the foreign contribution. But when you see the explanation, they have given a separate exception that the amount you are receiving as a part of fees, that will not be a foreign contribution. So that exception they have given. Then some foreign client is there. You are giving goods or services to the foreign client. Now the foreign client will make payment of the consideration. Whether that will come under foreign contribution? No. Only if you are not doing anything in return. Not doing anything in return, only that particular items will come under the foreign contribution. Here in return for the amount, you are sending the goods or services. So that is not a foreign contribution. So basically, whatever the article, currency, security you are receiving from foreign source, it will be a foreign contribution. Article, currency, security, donation, delivery or transfer from a foreign source. And here when you see these three are the exceptions. When you are getting the thing from the foreign source and that you are transferring, that is also foreign contribution. Deposit amount and in the interest, that will also be a foreign contribution. When you are getting a consideration for goods or services, that is not a foreign contribution. These three are the important points. Then here when you see in article, currency, security, for this article they have given an exception. What is the exception? If you are getting an article, it is a gift for personal use and then the market value is not more than 1 lakh. Up to 1 lakh you are having the market value. It is a gift. It is an article for personal use. So when you are getting these three conditions fulfilled, then it is not a foreign contribution. When you are receiving it as a gift for personal use, market value up to 1 lakh, then it is that article, that object, it is not a foreign contribution. So that is the meaning of foreign contribution. I hope you would have understood it. Now we can see what is the meaning of foreign source. So here foreign source, when you see, basically what are all the entities that are controlled from outside India. Entities that are controlled from outside India. All those entities will come under the foreign source. Here when you see the list, government of any foreign country, foreign government like American government, Russian government, everyone will come under the foreign source. International agency, not being the United Nations or World Bank or International Monetary Fund and any other agency specified in this behalf. So whatever the international agency, generally all the international agencies will be coming under foreign source. But specifically, United Nations when you take, or World Bank when you take, International Monetary Fund when you take, or central government will give you a list. All the entities in that list, they will not come under the foreign source. Generally, international agencies will come under the foreign source. These specific items, these specific agencies, they will not come under the foreign source. Then foreign company. Foreign company, that will also be a foreign source. It will also come under foreign source. Then any corporation incorporated in a foreign country or territory. It is not a foreign company, but it is incorporated in a foreign territory, foreign country. That will also come under foreign source. Multinational corporation, that will also come under foreign source. We will see the meaning of multinational corporation also. Then a company where more than one half of the nominal value of share capital, so more than 50% of nominal capital, when it is held by foreign government or foreign citizens or corporations incorporated in a foreign country, trust, society, other association, formed or registered in the foreign country, foreign company. These are all the foreign people. When these people have 50% of share capital owned in a company, then that company will also come under foreign source. More than 50%. This limit is important. More than 50% when they are having a stake in a company, then that company will also come under foreign source. Foreign government, foreign citizen, foreign incorporated corporation, and then trust society association formed in a foreign country, foreign company. These people, when they have more than 50% nominal capital in one company, that is also foreign source. Then, when you see in this format also, when you see based on this particular rule, you will get a lot of companies. In that also, we are having exception. When we are having a company, in that company, Foreign Exchange Management Act tells that up to a specific percentage only, the outside people, the foreign investment should be there. foreign investment should be there up to a certain limit only in these companies. Like that, the Foreign Exchange Management Act will give the instructions. So based on that, if the foreign investment is within the limit, then no problem. First, when you see based on this rule, all the companies in which more than 50% capital is held, then they will become the foreign source. But in the company, within the limit only, the foreign investment is there. From the based on the Foreign Exchange Management Act, within the limit only, the foreign investment is there. Then such company will not be a foreign source. That is an exception. Nominal capital held within the limits of FEMA. That is not a foreign source. That company is not a foreign source. Then trade union in a foreign country, that is a foreign source. Foreign trust, foreign foundation, that will also come under foreign source. Then society club association formed or registered outside India, that is also foreign source. Citizen of a foreign country, from the citizen you are getting some amount, that is also foreign source. And here one more point. In this, what is the important point? This important point you should note. From this they may ask you the question. Then here when you see the foreign contribution definition, this point is important. They are testing this in both IBS and then SET exams. So this is one important point. You can take a note of that. And from this explanation, they may ask questions from the explanation also. That also you should note. Then here they have given the single list. Like here when you see foreign government or its agency, foreign company, MNC, foreign trust society foundation, foreign citizen, foreign trade union, specific Indian companies, international agencies. These people will come under the foreign source. So what is the meaning of multinational corporation? That also we should see. A company incorporated outside India and it is carrying on business, it is conducting the business or has a subsidiary or branch. It is either conducting the business or has a subsidiary or a branch in or such place of business. It is having in two or more countries. So then it will be called as a multinational corporation. The simple meaning of MNC only they have given in a definition format. Then these points we already saw. Specific Indian companies means if it is an Indian company where more than half of nominal capital, more than 50% is held by these people, then it will become a foreign source. If the capital is held within the limit of FEMA, then it is not a foreign source. So this also we saw. All the international agencies will be foreign source, other than World Bank, IMF, United Nations, other agencies notified by the central government. Now the next thing we have to see, these illustrations we have to see whether earnings from the foreign client in lieu of goods or service, whether it will be foreign contribution. No, we already saw that when you are selling goods or services, that will not come under the foreign contribution. Then, can foreign contribution be received in rupees? This is one important point. Whether you are receiving rupees or dollars or any other global currency, that is not a thing. Whatever the currency you are receiving, that will be a foreign contribution. Currency, any currency, whether Indian or foreign, that will be a foreign contribution. Then, interest or any other income if you receive, that is also foreign contribution only. Then, donation given by non-resident Indian, whether it is foreign contribution. So, what is the meaning of non-resident Indian? Non-resident Indian means he is a citizen of India living in another country. Like non-resident Indian is the meaning. The meaning is citizen of India living in another country. So here they are saying that in the foreign source, citizen of foreign country. Citizen of foreign country will be covered in the foreign source. But what is NRI? He is a citizen in India only, but resident outside India. So that is why non-residential Indian. So he will not come under citizen of foreign country. So non-resident Indian is not a foreign source. So that is the conclusion. Non-resident Indian is not a foreign source. So whatever you receive from him, then it will not be a foreign contribution, not be a foreign contribution. Then whether 100% subsidiary of a foreign company in IT sector can give donation to trust who does not have registration under FCRA. And one more point, when you are going to receive any foreign contribution under the FCRA Act, you have to get the registration under the FCRA Act. Whatever the foreign contribution you are getting, you have to get the registration under the FCRA Act or you should get a prior permission. So for now you can understand you should get the registration. If you are not having the registration, whether the 100% subsidiary of the foreign company in IT sector, whether it can give a donation to the trust which is not having the registration. So that is the question. So the answer is yes, it can. It can provide the donation. So when you see as per FEMA, Foreign Exchange Management Act, this 100% subsidiary is allowed. This 100% limit is allowed under the Foreign Exchange Management Act for this particular company in IT sector. So this company will not be a foreign source. So here if you see the definition itself, if the nominal capital is held within the limits of FEMA. So under FEMA, when you see 100% is allowed for IT sector, so then that will not be a foreign source. 100% is the limit under FEMA. Within the limit only they are having 100% also allowed under FEMA. So that will not be a foreign source. Then when you are giving that amount to a trust, it is not a foreign contribution. So it was not a foreign source. Then no foreign contribution. Only when you're having a foreign source, then only foreign contribution will come into play. Then whether an individual of Indian origin who has acquired foreign nationality is treated as a foreign source. When it is a person of Indian origin but he acquired foreign nationality, it means that he has become a citizen of foreign country. Then he will be a foreign source only. Citizen of foreign country, he is a foreign source. Then, the next thing, what is the meaning of person? Under Foreign Contribution Regulation Act, person includes individual, HUF, association, and a company registered under 25 of the World Companies Act or Section 8 company. Individual, HUF, association, Section 8 company will come under the person. Then we saw foreign contribution and foreign source. Now we are having another term, foreign hospitality. What is the meaning of foreign hospitality? Foreign hospitality means when you are traveling outside India, the cost to travel outside India, free boarding lodging where you are staying, that particular expenses, free transportation within that country, or free medical treatment when you are receiving this from a foreign source, then that will also be considered as foreign hospitality. Foreign contribution means directly you are getting some amount. Foreign hospitality means for these expenses, that particular foreign source will make the payment. No need to do any payment by yourself. The foreign source will make the payment for all these arrangements. So that will come under the foreign hospitality. You are being treated by the money of the foreign source in a foreign country. So that is foreign hospitality. These two, why we are having the definition is that foreign contribution means you are getting directly amount. Just you can consider in short that you are getting something in money value, monetary value you are getting. So when you are getting the money, you will be working for them. So for that we should have a regulation. Otherwise, all the foreign forces, all the foreign entities, they will try to make payment inside the country and they will try to do whatever they want. They will make the payment for our Indian people and they will try to do whatever the activities they want through the Indian people. So you have to regulate that. Foreign hospitality, when an Indian is going abroad, when you are treating him well, you are seeing the travel cost, medical expenses, and then boarding cost, everything you are managing, then that person also will have one soft corner for you. Then, if that person is a judge and you are having a case in India, then that judge will be showing partiality for you for that foreign source. So that is the thing here. These things will influence Indian people, so that's why we are having a regulation for that. So we saw what is the foreign hospitality also. Now, we are going to see section number 3, prohibition to accept the foreign contribution. Some people, they cannot accept the foreign contribution. It is not allowed. So, for these people, receiving the foreign contribution is not allowed. Who are the people? Those are the influential people in our country, like candidates for election. If you are standing in election, you should not receive any foreign contribution. Then, if you are a correspondent columnist of a registered newspaper is there, the foreign entities should not control our newspapers. So, these people will also come under the list. They should not receive any foreign contribution. Public servant, judge, government servant, employee of any corporation owned by the government or any body controlled by the government, these people, persons working under the government entities, they should not receive any foreign contribution. Then, member of any legislature, MLA, they should not receive any foreign contribution. Political party or the office bearer, any person working in political party, these two people, political party and then the person working in that, they should not receive any foreign contribution. Then, organization of a political nature, it will not be a direct political party, but it will be a organization which is of a political nature. It will be involved in the political activities. So that will be given by the central government. The list will be given by the central government. Those people, they should also, those organizations, they should not receive any foreign contribution. Then association or company engaged in the production of broadcast of audio news or audio visual news or current affairs programs. You are not a direct newspaper. You are a news agency. You are broadcasting audio news. You are communicating news to people through audio or audio visual. You are using visual also. Or you are conducting a current affairs program. These are all the agencies which have direct reach to a mass number of people. So they should not receive any foreign contribution. Correspondent or columnist or owner of the association or company in clause G. So for this agency, news agency also, any correspondent, columnist, they should also not receive any foreign contribution. Then they have given the explanation like public servant meaning and in corporation meaning. That and all is not relevant from the exam point of view. Now, these persons should not receive any foreign contribution. So here if you see candidate for election, public servant, judge, employee of government owned company or government owned body corporate, members of legislature, political party, office bearer of political party, organization of political nature, persons associated with newspaper, news broadcasting entities and persons associated with it. So this correspondent, columnist, and this list we are having, right? Basically, all the people who are associated with a particular news agency or newspaper, they should not receive any foreign contribution. So this is the list. I have given you the charts also wherever necessary. Then we are having other things also. These are the prohibited persons. So directly from the foreign source to the prohibited person, there should be no payment. There should be no transfer. But we can have another situation. The foreign source will give to a person resident in India. This person will receive the foreign contribution. Then he will transfer it to the prohibited persons. So this may happen. For this only we are having the next subsection. This is not allowed. So when you are a person resident in India, you are receiving some foreign contribution from a foreign source. You should not transfer it to the prohibited persons. So this is the first point. Then, when you see from foreign source you are a person resident in India, you are also not directly giving to the prohibited person. You are transferring it to person 2. That person 2 will transfer it to the prohibited person. Then, here you are getting the foreign contribution, here you are getting the foreign contribution, here also the foreign contribution is going. This is also not allowed. Here what you should do, the person resident in India is having the responsibility. The person resident in India will, you should check whether the person 2 will transfer it to the prohibited person, whether there is a chance that the person 2 will transfer to the prohibited person. That you have to check. Only after that only you have to transfer. If you think that this person will give it to the prohibited person, then you should not do this transfer itself. When you are cutting it here, you will not have this particular transaction happening. So I will tell you one more time. From foreign source, person resident in India is getting. From him, person 2 will get. From him, the prohibited persons will get. When the person resident in India is receiving, he should check before transferring to person 2. What he should check? Whether this person 2 has any chance to transfer to the prohibited person. If he will transfer, then you should not do this transfer itself. You should not transfer to the person 2. So that is the thing here. Then this will apply directly giving to the prohibited person or giving through any other person to the prohibited person. These two will apply to the person resident in India and citizen of India and resident outside India. So for these two people it will apply, person resident in India and then citizen of India resident outside India, that is the NRI. For person resident in India and NRI, for these two people these conditions will apply. So that is the thing given here. Person resident in India should not deliver currency accepted from foreign source. From foreign source to the person resident in India, we are getting a currency. To any person, if reasonable cause to believe that such any person will deliver it to the prohibited person. From that person too, it will go to the prohibited person. If you know this, if you have a reasonable cause to believe this, then you should not deliver the currency. Then, Indian citizen resident outside India, not deliver currency accepted from foreign source to any person if there is a chance to believe that it is likely to be delivered to prohibited person, then that transfer also you should not do. Then this is also applicable for the Indian citizen resident outside India. You should not directly deliver to the prohibited person also. Then one more condition we are having, that is another section, but I will tell you now. Whatever the person, if he is having the certificate of registration or prior permission, a person he is having the prior permission or certificate of registration. So what is the meaning? He has the authorization to get the foreign contribution from the foreign source. So whatever the foreign contribution he is getting, he should not transfer to any other person. He can make payment, he can use it for the purpose, but he should not transfer it to any other person. He should only use it. He should not transfer it to any other person. Even if he is having the registration or prior permission, even if the other person is also having the registration or prior permission, that does not matter. He should not transfer it to any other person. The next section we are going to see is section number 9. Now in this section what we are having, just for what person you have received the foreign contribution, only to that person you have to deliver the foreign contribution. So we can take one situation, one example. From foreign source, person 1 is getting the foreign contribution. He is receiving it on behalf of person 2. Now, what person 1 should do? He should deliver it properly to person 2. That is the correct thing. He should not deliver to any other person. That foreign contribution should not be transferred. That is the thing. This is the transaction where you are directly giving to person 2. Then we are having another thing. Foreign source, person 1 is there, he is getting the foreign contribution on behalf of person 2 only he is getting. Now, before transferring to any other person, like he is going to transfer to person 3. So that this person 3 will go and transfer to person 2. So like that indirectly they are transferring. Now, before transferring to person 3, what he should check? He should check whether this person 3 will properly give it to person 2 or this person 3 will give it to any other person. That we have to check. If there is a probability that person 3 will give it to any other person, then you should not transfer to person 3. This transfer should not happen. So that is what they are telling. Directly, for example, if you are going to receive the foreign contribution on behalf of person 2, it should properly reach person 2. That is the only thing here. So that they have given here in the form of this particular section number 9. One more point, this particular section we saw at section number 9, this will be applicable only for currency. This transfer right, you should do it only for currency. Properly it should reach person 2. That is not for the general foreign contribution. It is for the foreign currency. When you are getting the foreign currency, this restriction you have to follow. That is what they have given here. Any person receiving any currency, that only is the main part. For currency only, this restriction is there. So that's all about section number 9. Now we can see section number 4. Section number 4 will tell where section 3 will not apply. What is section 3 saying? You should not deliver to these persons. You should not deliver to the prohibited persons. You should not deliver to any other person who will deliver it to the prohibited person. That also you should not do. You should deliver it only to the persons who are designated. Only for the persons for who you received it. So that is what being said under section number 3. In these transactions, section 3 will not apply. Like you are getting some salary, wages, other remuneration, then for that section 3 will not apply. In the ordinary course of business you are doing, then section 3 will not apply. You are not having any prohibition. Then you are making payment in the international trade, in the ordinary course of business, then also it will not apply. Then you are an agent of a foreign force. You are an agent of foreign force. The transaction is happening between foreign force and then the central government or state government. On one side, foreign force we are having. On the other side, central government or state government you are having. You are an agent of the foreign force. Then also this exception will not apply to you. This particular prohibition, it will not apply to you. You can freely receive the amount. Then, by way of a gift or presentation made to him as a member of any Indian delegation accepted in accordance with the rules. So, an Indian team, Indian delegation, it is going to outside India. It is going to foreign country. And as a member of Indian delegation you are going, so you are getting some gift. Then that gift you can receive, there is no problem in that. Then you are getting from the relative. From your relative outside India, you are getting some amount. Relative, he is outside India, he is sending to you, person. You are a person resident in India. Then no problem. Then also no problem. From the relative only you are getting the amount. And when you are getting from relative, there is no thing to receive the permission and all. But after getting 10 lakh rupees, if you are getting the foreign contribution in excess of 10 lakh rupees, foreign contribution means it can be in article, currency, security in any form. The total amount, if it is more than 10 lakh rupees, then you have to inform the central government in FC1 form within 3 months of receipt. You have to give the intimation. You have to give the notification, like this is like the notification you are receiving in mobile phone. Like that, you have to give the intimation, you have to give the information to the central government in this particular form within 3 months from the receipt. The month in the receipt. For example, whatever the date you are getting the foreign contribution, you are receiving more than 10 lakhs. From this date, within 3 months, you have to inform it to the central government in form FC1. So that is this point. Then from relative, this is an important point. They may ask you the questions. This intimation they may ask you from for which timeline. They will give you a case. In that, within the timeline, whether the person filed the form, that they will ask you. For that, you should know that 3 months is the timeline, deadline for filing the form. The limit also you should know. In excess of 10 lakh rupees you are receiving, then only you have to file this particular form. Then, by way of remittance, received in the ordinary course of business, through any official channel or authorized person, by official channel you are receiving, like banking channel, post office, authorized person, you are getting from them. Then also no problem. In the ordinary course of business you are doing. Then scholarship, stipend or any payment of the like nature, anything in the similar format you are getting, then also no problem. That prohibition section or that regulation and all will not apply. So section 3, this section 3 alone will not apply for these payment, salary, wages, ordinary cost of business, or this particular stipend, relative payment, gift, everything will be allowed. There is no prohibition under section 3. Then if you are receiving the amount for any other purpose, then that is in contravention of section 3. Then that means that you are not following section 3, you are breaching section 3. So for this purpose we can get, and that is the allowed purpose. If for any other purpose you should not get it. So that is the completion of section number 4. Now we can move to the next section. Before that, one more point we have to see in this section 4 itself. That point is here if you see, where foreign contribution is accepted for the above purpose, such contribution is exempted even if received by a person prohibited. So here we saw one list right in section number 3. This list, these persons should not receive any foreign contribution. But when they are receiving for this purpose, like international trade, central government, state government, agency transaction, gift, relative, in these cases, even the prohibited persons can receive the foreign contribution. There is no problem in that. For these purpose, whatever they want, they can receive. Even the prohibited person can receive the foreign contribution for this purpose, for this list. For that, we are having an illustration also. Whether foreign remittance received from a relative are to be treated as foreign contribution. No, it is not a foreign contribution, not treated as foreign contribution, even if received by a person prohibited. So that is what they are saying. This they may ask you in the exam. So this point I am telling you specifically. Now we can see the next point, that is section number 6, restriction on acceptance of foreign hospitality. This list, section number 3, this is for the prohibition to accept the foreign contribution. Now we have to see for the foreign hospitality. When you see for foreign hospitality, members of a legislature, MLA, office bearer of political parties, judges, government servants, then employees of corporation or body owned by the government. Now, these people, they cannot receive the foreign hospitality, the boarding, lodging, free medical treatment, cost to travel abroad, everything that will come under foreign hospitality that these persons should not receive. And if they want to receive, they have to make an application to the central government, and then they have to get the permission for receiving the foreign hospitality. For that we are having a procedure. So these specified category of persons, they have to first apply to the central government for prior permission. Then along with that application, one invitation should be there. What invitation? From the foreign country someone would have invited you to visit the country, right? That invitation should be there along with the application. And whether it is sponsored by any ministry or department, that also, that administrative clearance, everything should be there along with the application. The application should reach the authority 2 weeks before the date of journey. Whatever the date in which you are starting the journey, you are going to start to travel to the abroad country, then from that date 2 weeks before 2 weeks itself, the application must reach the authority. Whatever the date, from that before 2 weeks, here you are having 2 weeks before this point, the application should reach the authority. Then in case of emergent medical aid, so this is the hospitality which we are going on a planned basis. But sometimes when our people, Indian people, are in a foreign country, these specified category persons are there in a foreign country, but they got some emergency medical need, they are suffering from a heart attack or some other medical emergency is there for these people, then that time they cannot go and do the application and all for the emergency time period. So they can get the medical aid, and after getting the medical aid, they have to inform the central government. Normally when you are going, you have to get the prior permission, then you have to go. In case of emergency, what you have to do is that you have to get the medical aid, then you can inform the central government. So after getting the medical aid, you have to inform to the central government in what form. You have to get the um, you have to inform the central government within 1 month from the date of receipt of such hospitality, source, and then manner in which they received. In case of emergency medical aid, within 1 month from receiving the medical aid. Then if the medical aid value, the value of the emergency medical aid is up to 1 lakh, then that intimation also is not required. No intimation needed if emergency medical aid up to 1 lakh rupees. So this is the thing here. Then that's all about this particular section. Then the next section is section number 7. We already saw that any person who is receiving foreign contribution not transfer to any other person. If you are having certificate prior permission, you are receiving the foreign contribution, you cannot transfer such contribution. No person shall transfer the foreign contribution. Then the next section is section number 8, which is related to the administrative expense. This we can see it later. So now this section is section number 9, the next section, power of central government to prohibit the receipt of foreign contribution in certain cases. In some situations, the central government may pass an order that you should not receive any foreign contribution. You are not allowed. Like that, they may pass some order, prohibitory order. It is called as a prohibitory order. You are restricted from receiving the foreign contribution. You are not allowed to receive the foreign contribution. In what reasons? Why the central government will pass such an order? When the foreign contribution, if you are receiving the foreign contribution, it will be a threat to the sovereignty and integrity of India. It will be a threat to the national, what we can say, sovereignty or integrity. It will be a threat to the India nation. Then in the public interest, it will not be for the public good. So then also they can stop you. Then freedom or fairness of election to any legislature. An election is happening in India, and if you receive a foreign contribution, the election will be conducted in a wrong manner, or the election may be compromised. So in that case, they will stop you from receiving the foreign contribution. Friendly relation with any foreign state. If you are receiving the foreign contribution, other friendly foreign country, our relationship with that foreign country will get affected. Then also they will stop you. Harmony between religious, racial, social, linguistic, regional groups. It will create some kind of communal tension, or people will fight each other if you get the foreign contribution. You will use that to create some kind of tension in the country. Then in those cases also, they will stop you from receiving the foreign contribution. They can prohibit you. They can make an order that you should get the prior permission before receiving the foreign contribution. They may ask you to provide the information, like what all the foreign contribution you have received till now. That information they may ask you. Then same thing they have given. So in these cases, the central government will stop you from receiving the contribution. Then, when you are receiving any foreign contribution, that also in the contravention of the act. You did not properly follow the act, but you received some foreign contribution. Now, the central government will confiscate it. They will take it into their custody. Not confiscate, they will take it into their custody. They will seize the article currency security that you are receiving in the contravention of this act by an order. And they will also make an order that you cannot transfer this foreign contribution, you cannot deliver this foreign contribution, you cannot deal with this foreign contribution. Like that, they may pass such an order also. The order copy will be served to the person prohibited. Then, whatever the security you received, article currency security, the foreign contribution you have received, that will be seized. Then, the central government may issue a prohibitory order for contravention of the act in respect to any article, currency, or security. They will issue a prohibitory order. The prohibitory order, in this manner, they will deliver it to you. So that also they have given. In which manner they will provide it to you. So it may be delivered to that person or his agent. It may be given in the manner like registered post with acknowledgement due or speed post to the last known address. Then by affixing on the outdoor door or any conspicuous part, they will stick it outside. That also they can do. So that's all about this particular thing. Prohibition of foreign contribution received by certain persons. Now the next part is registration. So here in registration when you see we are having two types. One is the registration, other thing is the prior permission. So when you are receiving the foreign contribution, you have to take either registration or prior permission you have to take. What is the difference between these two? Whatever the foreign contribution you are receiving, you are going to do some kind of project or some kind of program which will help the people. It's for the social benefit of the society. So that is the thing here. Registration or prior permission, you are doing the amount, you are receiving the amount, using that amount for the benefit of the society. For the two kind of thing you are having. First one is registration. When you are doing continuous activity, not a one-time project. Continuously you will be doing it. For a long period of time you are doing it. In future also you will be continuing to do it. Then you can get the registration. And prior permission you can get when you are doing a one-time project. It is not your work. You are not going to do only a one-time project. After completing that, you will be doing your regular business or other work. You will not be there in this particular field of social benefit for a long period of time. Just a one project you are doing. Then it will come under the prior permission category. When you are taking the prior permission will be valid only for the specific purpose or specific amount. Like they may give you a limit up to 1 lakh US dollar you can receive with this prior permission, or for this purpose, like you are constructing a school for the benefit of people, then they will be telling this up till the construction of the school you can get the foreign contribution. After completion of the construction, you will not be able to get the foreign contribution using this permission. This permission will expire when the completion of construction is done for that particular school. Like that, they may give you the purpose or amount. Then registration you will get it when you are doing continuous activity. For this registration you should have some eligibility. What is the eligibility? Your organization, the Section 8 company, HUF, individual, that should be in existence for at least 3 financial years. And for those 3 financial years, you should have the audited financial statements. Audited financial statements you should have. Then the registration certificate you are getting, RC, that will be valid for 5 years. Standard time, 5 years it will be valid. Then 6 months before expiry, you have to do the renewal. This will be valid for 5 years only. At the end of 5 years, you have to do the renewal. 6 months before the expiry, you have to do the renewal. And one more thing, you should have spent 15 lakhs for the society benefit. For the benefit of society, you should have spent at least 15 lakh rupees. So then only you will be getting the registration. Now we saw what is registration, what is prior permission. That same thing only given here. Then if you are having a definite program, you are going to do a continuous activity, you have to get a registration, then only you can receive the foreign contribution. This is a transitional provision that is not relevant. Now, if you are not registered, you can get the prior permission also. That also we saw. Registration or prior permission. Any one of these two should be there. You have to apply in this form. FC3A you have to apply. For prior permission, FC3B you have to apply. When you are making the application, you should have an FCRA account. This is a specific type of bank account that you can open with any scheduled bank. That you will be telling that I need to open a FCRA account. So this specific category of account you should be opening. Not a normal account, special account. Now, central government, if it has any reason to believe that you have contravened any of the provision of this act, you have already not followed this act, then what the central government will do? It will direct the person to not utilize the unutilized foreign contribution. Already you are having some foreign contribution. Central government believes that you are not following that. Now they will say that whatever the foreign contribution you are having in hand, that you should not use it. and remaining whatever the foreign contribution you are about to receive, that also you should not receive without the prior approval of central government. Whatever the foreign contribution in hand, that also you should not use. And then future also you should not get any foreign contribution without getting the central government approval. Like this, they may give an order also when you are having the registration or prior permission. Even in that time also they can give this order. Then the central government may specify that this class of persons shall obtain the prior permission. Like that, they may give you a list. These persons, if they are having, they should get the prior permission before accepting the foreign contribution. Then where they can, in what area they can utilize the foreign contribution, for what purpose they can use it, the source from which they can get the foreign contribution, and these for all they may be specified in the central government official gazette. Then the person may open one or more accounts in bank. They may open one or more account in various banks. You can open various accounts and transfer the funds to those accounts and then utilize it. And all the accounts when you're opening, you have to give the intimation in the electronic form. FC6D. In this form, you have to give the intimation to the Secretary, Minister of Home Affairs, New Delhi, within 15 days of opening of any account. This point may be important. They may ask you in any MCQ. This is a point which is hidden, like it is not plainly available. When you see here, this and all, everyone will see. But this only some people will note. Many have the chance that they may leave this point and go. But this point, from this they may ask you one question. You have to give the intimation to the central government within 15 days of opening the account. Now, illustrations. Why these illustrations I am covering is that they are asking questions from this also. From this direct example or illustration, they are asking questions in both Set A exams and in the IBS exams. Can a private limited company or a partnership firm get registration or prior permission under FCRA? When you are getting a permission or registration, you need to be a person. Person means only individual, association, HUF, or a Section 8 company under this FCRA Act. So only if you are coming under this list, you can get the registration or prior permission. So here, private limited company, it can get it, but it should be a Section 8 company. Partnership firm, it is not allowed. Then, whether an individual or a HUF can be given registration or prior permission. Yes, under person, both individual and HUF is coming, so they can get the permission. Then, whether organization under central or state government are required to obtain registration or prior permission under FCRA for accepting foreign contribution. This is one more point which is in the nook and corner of study material, which may be important. From this kind of points only they are asking nowadays. Here when you see they are asking under central government, state government, they are having one organization. If that organization want to receive any foreign contribution, whether they should get any prior permission or approval. Here they are asking that generally yes. Generally if you want to get the foreign contribution, even if you are an organization under the government, you have to get the approval. But all the bodies constituted or established under a central act or state act requiring to have their accounts compulsorily audited by C&AG are exempted from all provisions of FCRA. But there is an exemption. What is the exemption? You are a body under a central act or a state act. There is a compulsory mandatory requirement that your accounts should be audited by C&AG, Comptroller and Auditor General. Then, in that case, all provisions of FCRA are exempted to you. This means that you don't need to follow even a single provision of FCRA. So, Central Act, State Act, under that Act you are a body and your accounts are compulsorily audited by C&AG. Then all provisions of FCRA are exempted to you. So that is the requirement given here. It is not given under any section, that and all they have not given, but it is an illustration. So they may ask it. Then grant of certificate of registration. What are all the conditions? For the person who is making an application, he should make in such form, such manner, fees you should pay. Then you should not be fictitious, not be binami. You should be a principal. You should not be working like a binami agent for some other person like that and all. It should not be there. You are not convicted for conversion from one religious faith to another. You are not in the conversion of faith business. Like you are converting one Hindu to Muslim, Muslim to Christian, and Christian to Hindu like that. You are not doing any conversion. In that, if you are convicted, then you cannot get the prior permission or then the registration. In that kind of thing, you should not be involved. Not convicted for communal tension. Not prosecuted or convicted for communal tension. You are not convicted for creating tension among the people. Then not found guilty of diversion of funds. If you are found guilty of diversion of funds, you are diverting the funds for the other than the purpose for which it was received. Then that also it is an ineligibility. Then you will not be able to receive the prior permission or then the registration. You are involved in sedition or advocate violent methods to achieve the ends. then in that case also you are a violent person. You will be giving weapons to the people and then starting some violent movement. That and all is not possible and it is not allowable. So then also you will not receive the permission. Then you are likely to use it for personal gains and undesirable purpose. You are not going to use it for the specific purpose. Then also you will not be receiving it. You have not contravened this act. So you should not be breaching this act. You should follow this act properly. Mandatorily, you should follow this act. All the compliances you should do. Only then you will be getting the permission. Not being prohibited from accepting foreign contribution. Not already banned by the government. You are not prohibited. Already the government has passed an order that you should not receive foreign contribution. Then in that case it is not possible. But not prohibited, not banned. For these conditions you should satisfy. You should not be fictitious, you should not be binami, you should not be prohibited, you have not contravened the act. So in these cases, you will be getting the foreign contribution permission or then the registration. Then here, if you are making an application for registration, you should have already done a reasonable activity in the field for the benefit of society. If you are getting the prior permission application, you should be having a reasonable project for the benefit of society. Then you were not convicted or any prosecution or nothing is pending against the individual. If you are an individual, you are not convicted, no prosecution is pending, no case is pending. Then, if you are a person other than individual, like you are a HUF or some other Section 8 company or some other association, all the directors or office bearers, not even one director should be having any case or should not be convicted, and any case should not be there pending against him. All the directors, all the office bearers, all the people should be clean. Then what when you're receiving the foreign contribution, it will not threaten the nation, it will not give any harm to the economic interest of the state, it will be in the public interest, it is not against the public. Then it will not create any harm to the fairness of election, it will not affect the friendly relation with foreign state, it will preserve the harmony, it will not threaten the harmony. These things should be maintained. Only if there is no problem for these aspects, you will be allowed to receive the foreign contribution. Then you should not receive the foreign contribution to do an offense. For doing criminal activities and all, you should not receive the foreign contribution. It is not allowed. You should not endanger the life or physical safety of any person. For doing a murder and all, you are receiving the foreign contribution. Then that and all is not allowed. So these are all the conditions you should satisfy. Then procedure. What you have to do, you have to make the application. This application form, you have to do the application to the central government. Central government will grant you the permission or the certificate of registration within 90 days. This time limit is important. Within 90 days, they have to give you the certificate of registration or then the prior permission. If the central government is not giving you, it is saying that no, we will not give you the registration, we will not give you the prior permission, then they should give the reasons why they are not giving it. They have to record the reasons and provide it to the applicant, person making the application. Certificate of registration is valid for a period of 5 years. Prior permission is valid for specific purpose or specific amount. So this thing itself, this process itself, they have given in detail, so you can read it. And one more extra point alone here we are having. The central government may not communicate the reason for not giving certificate of registration or for not giving prior permission when there is no obligation under the RTA Act 2005. So here they have given that when they are not giving, they have to provide you the reason why they are not giving you the registration. They have to provide the reason in writing, record and provide the copy. It should be in writing. But there are some cases. In some cases, if there is no obligation under RTA Act, Right to Information Act, we are having RTA Act. Based on that, you can get any information from the government or records. You can apply and get it from the government done. So that information you can get from RTA. Under RTA Act, if such case there is no obligation on the government to disclose, then they will not tell any reason to you. If there is no obligation under the RTA Act for your particular case to give the information, then no need to give the reason. The central government will not give you any reason. Then, if you are making one application and that application is there, you shall not make a second application within a period of 6 months after submitting one application, either for prior permission or registration. For example, now you are making an application, then for the 6 months you should not do any application. After 6 months only you can start to do a new application. Whether the application got rejected and all, that does not matter. After 6 months only you have to start a fresh application. Then if you are going to get prior permission, you are going to make application for prior permission and the value of the foreign contribution, you should tell the amount, for how much amount you are getting the prior permission, that you have to mention. If the value of the foreign contribution is more than 1 crore, then the central government may give you a condition. What will be the condition? You should get the amount in installment. Installment means like 4 or 5 installment. Total 1 crore amount, you can get 20 lakhs per installment. Like that, you can get in 5 installments. So that may be one condition that is imposed by the central government. Like that, the central government can give you any condition. That power also they are having. And the 5 installments you are getting, right? For example, you have received the first installment of 20 lakhs. 20 lakhs you have received. Before receiving the next 20 lakhs installment, you have to provide the proof. What proof you have to give? Utilization proof that you have utilized the 20 lakhs properly. Not for 100%, but some 70% of that you have to provide the utilization certificate. You have to produce the proof that 70%, 75%. 75% of the previous installment 20 lakhs is utilized properly. After that only you will be getting the next installment of 20 lakhs. After that only you will be allowed to get the next installment. So that condition they have given here. They have to produce the utilization report, proof of utilization, and then the field inquiry they will conduct. After that only they will give you the next installment. They will give you the permission to receive the next installment. And whenever you are making application for prior permission or registration or renewal of registration certificate, in that case you have to provide the identification document. Individual and the directors in the Section 8 company, for those people you have to provide the Aadhaar number. That is the identification document for citizens of India. Then the next part is suspension of certificate. You are getting a certificate, but the central government is having a doubt if you are following the act or not. The central government is having a doubt. You are doing any contravention. The central government is having a doubt. Now, before cancelling the certificate, they have the power to cancel the certificate. They will not directly cancel it. They will first do the suspension. They will suspend the certificate. They will make an inquiry. After that, they will decide whether we can cancel or not. So, for that they will do the suspension of the certificate. Like when the central government is considering the cancellation, meaning that they are thinking, they are conducting an inquiry whether we can cancel or not. In that time period, they can suspend the certificate. Then what will happen? The suspension will be for 180 days. The suspension is for 180 days. This is one important point. They may ask you an MCQ from this. And the extension also 180 days. Originally for 180 days we can do the suspension, and if you want you can extend this by further 180 days. So this is the period of suspension for the certificate. During the suspension, what will happen? You should not receive any foreign contribution newly. Whatever the foreign contribution you received, that is okay. Newly, you should not receive any foreign contribution. But if there is an emergency situation, you want to receive the foreign contribution, you can make an application to the central government. Then the central government will give you the approval to receive the new foreign contribution during the suspension period. Based on some conditions they will put, then they will give you the conditions, and on what conditions you have to receive the foreign contribution. That they will tell you. Then not utilize the foreign contribution in his custody without the prior approval of central government. The amount you are already having, foreign contribution in hand, that also you should not utilize without the prior approval. After getting the approval, you can utilize. During suspension, you should not utilize. But if you want to utilize, apply to the central government, get the approval, then you can do the utilization of the foreign contribution in hand. Then during suspension, how much amount you can utilize? If your certificate of registration is suspended, up to 25% of the unutilized amount may be spent with the prior approval of the central government. Remaining 75% shall be utilized only after revocation of suspension of the certificate of registration. So here, for example, 100 crore rupees, you are having the foreign contribution in hand. We already saw that we cannot use even 1 rupee of the amount without the central government approval. Now what we can do? We can go make application to the central government and get the approval of the central government. Even after getting the approval, you can spend only 25%. Remaining 75% you can spend only after the suspension is cancelled. Only after the suspension is cancelled. After that only you can spend the remaining 75%. So 25 crore you can spend now after getting the approval of central government. Remaining 75 crore you can spend only after cancelling the suspension. Suspension should be revoked. Then only you can spend the 75 crore. That point they have given here. Then cancellation of certificate. When they can permanently cancel your certificate. So when you are making an incorrect or false statement in the application for the grant of registration, you have to make an application, right? Application for registration. In that application, you made some mistake. You have given some incorrect information or false information you have given. Then you have violated the conditions of certificate. In the application, you have given the application, you got the certificate. In that certificate, some conditions are there. That conditions you did not follow properly. You have violated the provision of the act. You have contravened the act. You have not followed the act properly. Then also they can cancel. Then, if the holder of the certificate not engaged in reasonable activity for 2 consecutive years or become defunct, you received the amount but you did not do any activity. You received 100 crore rupees by saying that I will construct a school, I will construct a hospital. Like that, you told and received the amount, but you did not even start the construction. So, in that case, also, for 2 years, you did not even start the work. Then, also, your certificate will be cancelled. Next point, if it is necessary in the public interest, for the good of the public, we have to cancel your certificate. Then also they can cancel the certificate. Incorrect or false statement, violated the conditions, violated the act, not engaged in the work for 2 consecutive years, you have become defunct, you have not been functioning. The organization has become defunct or it is necessary in the public interest. In these cases, your certificate will be cancelled. For finding out this, for getting the evidence for this only, they will suspend your certificate and do the inquiry. Then, before doing the cancellation, before cancelling the certificate permanently, they will give you a reasonable opportunity of being heard. They will give you a time. You can tell your side of the case. You can make an what we can say statement that what happened, why you are not able to do the activity, or why you have done these kind of violations. That you can give your explanation. After giving this opportunity for doing the explanation on your side, then only they will do the cancellation. Then, if your certificate is cancelled, then what will happen? You shall not be eligible for registration or prior permission for a period of 3 years from the date of cancellation. From the date of cancellation, 3 years you will not be eligible. After 3 years, you can give a new application. You can make the application for a new registration certificate. So for 3 years, you cannot apply again. So that is the point here. Cancellation of certificate is done. Now the next thing is surrender of certificate. A request may be made to the central government for surrender of certificate. Now they are cancelling, that will come under this particular section number 14. Surrender means you are surrendering by yourself. You are telling that I am not requiring the certificate now. There is no need for me to get the certificate now. So I am surrendering the certificate. I am voluntarily giving the certificate back to the government. That will come under section 14A. The central government will make an inquiry and they will confirm that you are not contravening, you are not breaching any section of the act, you are not violating any section of the act, and after that they will take the assets, whatever the foreign contribution you have received or whatever the assets that you have created out of the foreign contribution, like land, building, securities you have purchased or bonds you have kept, all the things they will take it from you. They will vest it in the appropriate authority. They will be giving it to the appropriate authority after surrendering the certificate. The central government may permit any person to surrender the certificate granted under this act. You are making a request. After that, the central government will give you the approval to surrender the certificate. Then, if the certificate is surrendered, the validity will be considered to be expired. It will be considered that the certificate got expired. Then, voluntary surrender. This is the form in which you have to make the application. Now the next section we are going to see is section number 15. Here, when you are having a certificate of registration, it gets cancelled or you are surrendering it. Then what will happen to the foreign contribution or then the assets created out of the foreign contribution that you were managing when you were having the certificate? Now you are not having the certificate. So what will happen to this foreign contribution or the assets? For this, we have to wait for the central government to issue detailed directions in this particular matter. But till now, what will happen? The foreign contribution or then the assets, it will vest in the banking authority. The bank will take care of it till the central government will issue the further directions. Till that, banking authority will manage that. And for this purpose only, for giving the directions, they have created the Foreign Contribution Regulation Amendment Bill 2026. But it did not get passed, so there is no fear for amendments and all. This did not get passed, so no amendments in FCRA Act till now. When we are getting the bill passed and after that it becomes the Amendment Act, then we will get the amendments, then the ICA will notify it in the study material, we will get the new study material. After that, we have to see whether any amendments are there, what amendments are there, that we can see thereafter. So, till now there is no amendments in this regard, no need to panic. So, that I wanted to tell you here. So till now it will exist in the banking authority. In the Amendment Act, they have created a designated authority, like that some concept they have created, and that authority will manage all the assets and then the foreign contribution of the organizations whose certificate has been cancelled. But that the amendment bill, it did not get passed. So it is not an act till now. Now the next thing. That's all about this particular amendment bill that I have told you. Nothing to worry about. Just if you read this, it will be enough. Now the next thing, when you see a role of the authority. Role of authority means what will the authority do? It will manage the activities, it may utilize the foreign contribution, everything it will do as per the directions of the central government. Then if the person, organization, again he gets a certificate, the original certificate gets cancelled, he is getting a new certificate. Then all the foreign contribution as such everything will be returned to the organization. Now, renewal of certificate. We saw that the registration certificate, it is valid for a period of 5 years, and 6 months before expiry you have to renew the certificate of registration. It should be renewed within 6 months before the expiry. So, for example, if it is expiring here, before 6 months you have to take. In this period, you have to make the renewal application. Now, the next thing when you see here, this is the form for filing the renewal application. You have to file it within 6 months before the date of expiry. The fees is 5,000 rupees for renewal application. Then, if the certificate of registration expired, then you cannot receive the foreign contribution or cannot utilize the foreign contribution until you have renewed the certificate. If you are not giving any application for renewal, then after 5 years, the certificate will be cancelled automatically as per the previous term given. As per the original registration certificate, it will be cancelled after 5 years. So, whatever the balance unutilized in the FCRA account, it will go to the prescribed authority. Then, if the validity of the certificate expired, it has ceased, then you have to give a fresh request for a certificate of registration. You have to apply for a new certificate only. Then, period of renewal of certificate. After making the application, the central government, it will take time period of 90 days to provide you the renewal. After renewing, it will give you a renewal certificate for 5 years again. Again, for 5 years, there is no problem. Before giving the renewal certificate, the central government will make an inquiry whether you are properly following the act, you are not violating the act. That they will check, and then they will give some additional conditions also if there is any. If there is a need for giving additional conditions, they will give that conditions also as a part of the registration certificate. Then procedure where certificate has lapsed or ceased to be valid. You did not file the renewal application and the certificate expired. Then what will happen? You are having one relaxation. In that relaxation, if you are providing the sufficient cost, you are giving proper reason, then what you can do, the central government will give you the time. You can pay a late fees of extra 5,000 rupees, original 5,000 plus this late fees 5,000 you can pay, and you can give a renewal application. Then they will see that application. This can be done not later than 1 year after the expiry. For example, this is the date of expiry. This 6 months you should have filed the renewal application, but you did not do. Now from here 1 year you are having. In this 1 year you have to give the late fees along with the original fees, and you have to explain the reason also. Then there is a chance that they may accept your renewal application. So that's all about the renewal of application. Now the next topic is accounts, intimation, audit, and disposal of assets. So what all the accounts you need to maintain, what all the intimation you have to give. There is an intimation that you have to file with the central government. Audit, when will audit happen for the organization? Disposal of assets, what will happen to the assets? So whenever you are receiving the foreign contribution, you have to receive it through an FCRA account. This we already saw earlier. When you are making the application itself, you should have an FCRA account. That FCRA account, you should open it in the State Bank of India, New Delhi. The branch of State Bank of India in New Delhi, it is in Sansad Marg. So in that particular branch, you have to open the FCRA account. So what is the purpose of this? When you are getting the amount, foreign contribution from the foreign source, it should be going through the FCRA account in the State Bank of India, New Delhi. After that, you can open the FCRA account in other scheduled bank for utilization. So originally when you are getting it from the foreign source, it should be received in the FCRA account in the State Bank of India, New Delhi. After that you can route it through other FCRA account in other scheduled bank. This also in scheduled bank only you can open. That also special category FCRA account you have to open. To that you can transfer the amount and do the utilization and all. So that information they have given here. Then the State Bank of India branch, the New Delhi branch, and then the other scheduled bank where you are having the account. The bank branch should report to the authority. What they should report? The amount of foreign remittance, how much they got, what is the source of the remittance, other particulars, everything they have to report to the authority. Then whatever the transaction that is happening in the account, in the original account and in the other scheduled bank account, FCRA account, the bank should report to the government within 48 hours of the transaction. So that is one more requirement they have given here. 48 hours of the transaction. Whether or not registered, even if the person is not registered, certificate not valid, that and all you need not see. Whenever the transaction is happening in the FCRA account, within 48 hours you have to report it to the central government. So that is the thing here. Next, intimation. Intimation, it is under the section number 18. Here you have to give the information, have to file something like a return to the central government. It should include the amount of foreign contribution received, the source from which you received, the manner in which you utilized, and then the purpose for which you utilized it. So everything should be there in the particular intimation. Then you have to file an annual report also. That annual report, it should be signed or it should be electronically signed, digitally signed. That should be in form FC4. This is the form for the annual return. So this they may ask you the question, what is the form for the annual return? That they may ask you. In this form, what it will be there? All the required particulars will be there. Along with that, you have to furnish the scanned copies of the income and expenditure statement, receipt and payment account, and balance sheet. They have not given the profit and loss account because it is a charitable organization. You are operating for the benefit of the society. So income and expenditure statement, receipt and payment account, balance sheet, you have to give it to the government. Along with this, form FC4 within 9 months from the closure of the financial year. This time limit is important. They may ask this as a part of the question. They may give you a situation and say whether the company, whether the section company or the charitable trust, whether they have filed the proper form within the timeline properly. So that they will ask you. For that, you should note that 9 months is the time limit for the annual return. This is an important point. Then the annual return shall reflect the contribution received in the exclusive bank account in the State Bank of India bank account in New Delhi. In that branch, how much you received, that should be there, and from this, how much you transfer to the other branch, other FCRA account, how much you transferred, that also should be there in the annual return. Then, if you are getting only articles, only items, objects you are getting as foreign contribution, then this form FC1 you have to file. If you are getting foreign securities, you have to file FC1. So like this, we have given the separate forms for these two situations. Then whatever the form you are filing, form FC4, it should be signed. It should be what we can say certified by a chartered accountant. A chartered accountant should certify that. This is an important point. They may confuse you. Like the company's statutory auditor only should give the certification for this annual return. Like that, they may ask you. But any chartered accountant can certify it. It is not necessary that the statutory auditor should be there. This is one more important point. They have asked it in IBS in some PYQ also. And this also they have asked in some PYQ in IBS. So this is an important point. That is what I am telling you. Then here, the accounting statements shall be preserved by the person for a period of 6 years. So whatever the accounting statements you are having, the above accounting statements, these statements you have to preserve it for 6 years. That is another requirement. If you are not receiving any foreign contribution in a financial year, you have to file a nil report. If you have not received any foreign contribution, not utilized any foreign contribution, no need to give a certificate from chartered accountant or the income and expenditure account, payment account, receipt and payment account, and balance sheet. So, when you are not receiving any foreign contribution or not utilizing any foreign contribution, this chartered accountant certificate not required, and income and expenditure, receipt and payment, balance sheet. These three statements are not required. The next part is maintenance of accounts. You have to maintain the proper accounts for the foreign contribution you are receiving. Whatever the foreign contribution received, proper accounts should be maintained, and then where you utilized that, for that proper record should be maintained. You should maintain a separate set of accounts for the foreign contribution. Do not mix it with the local receipt and all. So keep a separate account and records for the foreign contribution separately. Then, when you are not giving the intimation, this intimation you have to give right that you are not giving, or you are not filing the annual return, or the intimation that you filed it is not proper. The central government will have a doubt whether you are following the law properly or not. If they have a doubt that you have violated the act, then what will happen? They will appoint an officer, and that officer will audit your books of accounts. They can enter into your office and they can do the audit. Then whatever the information they get, they have to keep it confidential. That information is there. They can do the audit if you are not doing the filing of the returns, or your returns are not proper. Then intimation by candidate for election. When you are a candidate who is standing for an election, you have to give the declaration that what all the foreign contribution you have received, that you have to give the information within 180 days, immediately preceding the date on which he is duly nominated as the candidate. So here we are having the candidate for election. When this is the nomination date, the previous 180 days. In this days, whatever the foreign contribution you receive, you have to give the information. When you are a candidate for election, you have to file the form FC1 in electronic form within 45 days from the date on which you are duly nominated. So for this 180 days, you have to give the information. This information you have to give the timeline to file, that is 45 days. So this is the filing timeline. This is the period for which you have to give the information. So that is the candidate for election. When you are a candidate for election, this requirement you are having under the Foreign Contribution Regulation Act. Then disposal of assets created out of the foreign contribution. When you are becoming defunct or your organization is not there, then what will happen to the assets? It will be disposed of. That information they have given here. So the next thing is adjudication. So till now what we have seen, whatever the account you have to maintain, the special foreign contribution regulation act account we saw, intimation, audit, disposal, everything we have completed till now. Now the next part is adjudication. Now in adjudication, when you see, when the government or some officer has the doubt that you are violating the act, they are having a reasonable cause to believe that you are violating the act, then what they will do? They will enter your premises and then they will seize the articles, foreign contribution, documents, amount, everything you have received by violating the act. That and all they will seize and go. After seizing, it will be started as an investigation. They will start a case and then the judge will hear both the sides and they will give a judgment whether you actually violated the act or not. So they will seize the articles and then after that they will conduct the case. In that case you will be adjudged. They will give you the judgment whether you actually violated the act or not after hearing both the cases, both the case of department and then your case. After hearing that they will give you a judgment. Now that is the meaning of adjudication here. When the value of the article currency security, yes means article currency security, is up to 10 lakh, the value is up to 10 lakh, then the officer will do the adjudication. The officer will be the judge. Which officer? An officer not below the rank of assistant sessions judge. Minimum assistant sessions judge should be the officer who is adjudicating it. If the value of article currency security is adjudicated by court of session, there is no limit. When the limit is up to 10 lakh, you can use this officer. But when you are doing court of session, there is no limit. Whatever the value, you can do the adjudication by the court of session. Normally, court of session means no limit for the value. When you are going for sessions judge, assistant sessions judge, the cap is 10 lakh rupees. Up to 10 lakh rupees only you can use this officer. If you have more than 10 lakh, you have to go to the court of session, which should be within the local limits of the seizure, in the place where you seized the products, seized the articles, foreign contribution, everything. In the local limit, whatever the court of session it is there, in that court you have to go and get the adjudication done. Now, the person will pass the order, court of session or the officer, he will pass the order. That order will be passed for disposal of the article currency security. So, they will tell it to dispose the article currency security. Of the disposal in what manner they will do? It will be in the form of confiscation. That is one type. Confiscation means the government will take away the property. They will take it as their property. They will take away your ownership and then you will not be the owner. They will confiscate the property. That is the meaning of confiscation. You are no longer the owner of the property. The second type is delivery of the article currency security to the persons claiming to be entitled to its possession. Originally, some people will come and say that they are the original owners. Now, those foreign contribution, it will be given to the original owners. These are the two kinds of disposal method for the foreign contribution or the assets. Now, that only they have given here. Section number 29, that we have given in the form of charts. And this charts I am not giving for each and every topic. Just for certain topics I am giving the charts. If it is possible, I can give the charts for every subsection, every section also. But it will not be fruitful. You should read the illustration and then the points also. Here, whatever the illustration and all you are having, right? This illustration and all, you should learn. You should read at least once. Only then you can answer the in-depth questions that they are asking. Sometimes they are asking questions from this illustration and all. Many people will not cover this and all. They will just cover the concept. But now I am specifically covering this because they are asking from this. So that's why it is taking a little bit of time. I have planned this session originally for 1 hour only. But since we are going a little bit in-depth, so it is taking a lot of time extra. So now that is the thing I wanted to tell you. Now this chart you are having, this you can refer to it for the specific topics for which I am giving the chart. Then the next thing when you see, the appeal you are having, right? The court of session passed an order or the officer passed an order, you have to go for an appeal. You can go for an appeal. Where you can go? When the sessions, court of session, it passed an order. When the court of session passed an order, you have to go to high court to appeal that. If the officer is passing the order, you can go to the court of sessions. So, from officer, you can go to court of session. From there, you can go to high court. If you are already starting from court of session, you can directly go to high court. So, that is the appeal procedure. Appeal, you have to give time limit. The time limit for appeal is 1 month from the date of communication of order. The court may allow extra 1 month also. So, normally 1 month is the time limit. If the court decides, it can give extra 1 month also. Now, that is the appeal. So that provision they have given here. Then we are having some specific orders like I will tell you one more point. Section number 5 we can take organization of political nature. I would have told you in short about what is the meaning of organization of political nature. An organization which is doing political activities but not registered as a political party. That is a political organization. Now, how we will decide whether the organization it is an organization of political nature or not? So that will be decided by the central government. The central government will see the activities of your party, the ideology of the organization, everything they will see. And after that, they will decide whether it is an organization of a political nature or not. They will pass an order saying whether the organization is of political nature or not. If the order says that you are an organization of political nature, or they are saying otherwise, and you are having an grievance with the order, you are aggrieved by the order under this section. Agreed by the order that saying that you are becoming an organization of political nature. So against that order also you can go for an appeal. And we are having other orders also. Order for giving prior permission, order for not giving the registration, like that. For those orders also we can go to appeal against the central government orders. Cancellation of certificate, against this order also you can go for an appeal. Appeal should be going to High Court within 60 days from the date of the order. So the appeal should be 60 days from the date of the order. Here one point which you have to note is that this particular appeal to the order passed by the court of session or the officer, that is from the date of communication of the order, from the date in which you got the order communicated. But here when you see it is from the date of the order. From the date of the order itself, you have to go to the appeal. That one thing you have to note it down. The next thing when you see here, revision of orders by the central government. When central government has passed an order and they want to revise the order, they want to change the order, modify the order, or do some modification to the particular order, they can do it on their own, or some person will do the application for revision. The person registered, the person having the registration, they can make an application for revision of the order. They can reconsider the case and then they can pass a fresh order or change the order. So the central government will see the case and they can see whether a new order is required, whether any modification to the order is required. So they can do it on their own motion also. If they want it on their own, they can do the revision, modification. Now that they cannot do it for more than 1 year previously. So for the orders done in the past 1 year, for those orders only, the central government can do the revision of order on its own motion. On its own, if they want to, it should be the past 1 year orders only. Order passed before 1 year, that they cannot do the revision of orders now on their own. Then, when a person is making the application for revision, it should also be made within 1 year from the date on which order was communicated. So, the date on which order was communicated, from that date within 1 year you have to make the application for order revision. If the central government is satisfied that there is a proper reason for not filing the revision of application order, that application for revision of order you have not filed within 1 year, for that proper reason is there, then the central government may admit the application even after the 1 year time limit. Then one more point here, after getting the central government order, you are having the time limit for appeal, right? You can go to appeal within 60 days. When the time limit for appeal is active, the central government cannot do the revision of order. Only after the time limit is completed, after that only the central government can take up the case for revision of order. That point also they have given here. You have to pay the fees also along with the application. So that related points they have given here. Then the next thing when you see offences and penalties. So all the offences and penalties is given in a chart format, like a table format here. Section 33, false intimation or fraud. You are giving a false information or fraud you are doing. Then imprisonment up to 6 months or fine or both. It is there. So like that penalty is there for each and every problem. Contravention of prohibitory order. They have passed an order that you should not deal with foreign contribution, but you are dealing with it. Then imprisonment up to 3 years or fine or both. Additional fine also they have given. Illegal acceptance of foreign contribution. You are accepting illegal, not in line with the act. You are violating the act. Then also imprisonment up to 5 years or fine or both. Failure to confiscate. Then you have done some actions, because of that we have to confiscate the article currency security, but that is not available for confiscation. Then also it is a wrong in your part. That thing you have hidden it somewhere, or you have destroyed it, or you have changed it, like that it is not available for confiscation. So in that case also fine not exceeding 5 times the value of article currency security, or 1000 whichever is more. Then section 37, general penalty. Any other place where there is not any specific penalty, where there you have to follow the general penalty. Imprisonment up to 1 year or fine or both. Then when you are a repeat offender, second conviction, when you are having a second conviction, you are repeatedly doing the offence. Then you cannot receive any foreign contribution for a period of 5 years from the date of subsequent conviction. So these penalty you are having, I am not going in detail into that, because it is just a technical point only, mechanical point. When you are doing this fraud, this penalty will be there, so that you can do it by yourself. So that only here they have given in the form of a detailed table. I have given it in the form of a short and concise table. Then offense by a company. When the offense is done by a company, all the persons in charge, directors who are responsible, and the company, everyone will be found guilty. If someone proves that without my knowledge the offense happened, someone in charge of the company, they proved that without my knowledge the offense happened, then they will not be liable. If the government or the department proves that with your consent or with your knowledge only the offense happened, then you will be liable. That only they have given here. Then, bar on prosecution of offences under the Act. Under the FCRA Act, if any court wants to start to conduct any case, then the court has to get the approval of the central government. After getting the central government approval only, you can go to the court. If you are also going to a court for an offence under FCRA Act, first you have to go to the central government, get the approval. After that only you can go to the court. Then only the court can take up the case. Then compounding of certain offences. In some offences under the Act, they will give you a choice like imprisonment or fine or both. This will be the case. In that case, there is a probability that only fine they can impose it and they can leave you. So in those kind of offences, where imprisonment or fine or both, in this any combination is there, like only fine or imprisonment, like this these combinations you are having in the particular offences. Then in those offences you can go for compounding. What is the meaning of compounding? You are going to the person and authority and telling that I will pay the fine, penalty, everything I will pay. You can stop the case and you can stop the prosecution. Like that you are making a request, please stop the prosecution, I will pay whatever the fine amount everything is required, I will pay the penalty. So they will stop the case and they will drop the case. So those offence punishable, not being an offence punishable with imprisonment only. If an offence is punishable only with imprisonment, for that offence only imprisonment is there as a punishment, then you cannot do the compounding. Only fine or just fine, imprisonment or fine or imprisonment. In those cases only you can go for the compounding. So you can go for compounding, they will tell you the amount, you have to pay that and they will drop the case. Then for that you are having a time limit of 3 years. For example, now you are doing the compounding. Within 3 years you are doing the same offence. Then for the second offence you will not have the option. That option of compounding will not be there. So that is the restriction we are having. First offence you are doing the compounding. Within 3 years you are doing another offence. For the second offence you will not get the option to do the compounding. Then after 3 years, now you are doing an offence, you did the compounding, 3 years completed. Then after 3 years, here if you are doing some offence, for this offence it will be considered as a first offence only. If you are doing any offence within the time limit of 3 years, here if you are doing any offence, then it will be considered as a second offence and you will not have the option of compounding. But after 3 years if you are doing, it will be considered as a first offence only. That point also they have given here. So here if you see, this compounding, that only they have explained, that you can read it. I have given you the meaning of what is the compounding. Then miscellaneous. Power to call for information or document and investigation into cases under the Act. So here if you see, inspection for contravention of FCRA. When you are violating the FCRA Act, they can do the inspection. The inspector will have the following powers. They can call for the information. They can demand you to produce the document or the item. They can examine any person. So these are all the powers available to the inspector under the FCRA Act investigation. So that they have given. Then any offence punishable under this Act, they can be investigated by any such authority as the central government may specify. The powers of such other authority will be there, like an officer in charge of a police station. Those powers will be there with that such authority also. So like that, they have given additional point also. Then the central government can give directions under the Act. The central government can make rules under the Act. The central government can exempt some persons. For some reasons, they can exempt some persons from the provisions of this Act. So those persons, after getting the exemption, they need not follow the Act. Even if they do not follow the Act, there is no problem. Then this Act will not apply to the transaction when it is happening between Indian government and then foreign government, between two government, Indian government and then foreign government. Between these two people, when some transaction is happening, then the Act will not apply. Then this Act shall be applicable in addition to, not in derogation of such other Act. So that also they have given. That is one more point. So that's all we have completed everything in this chapter. And one more thing we have to see is that the administrative expenses point. So the utilization we are having right here, the utilization. whatever the foreign contribution you are receiving, that you have to use it for the purpose, like construction of hospital, construction of school, or doing eye surgeries for the underprivileged people, or doing something for the benefit of the society. For the main purpose, we should use it. We are having some admin expense like accounting, legal fees, or electricity, water, staff salary. These are all the administrative expense. You cannot spend all the amount for this administrative expense itself. You should spend for the main purpose. For this admin expense, only to some limit only you can spend. For example, you are getting a total of 100 crore. 20% up to 20 crore only you can spend for the administrative expense. So that is the provision here. So you can utilize the such contribution for the purpose for which you have received it. Utilization should be done for the proper purpose only. You should not utilize it for speculative business. Speculative business means investing in the share market, or where there is a chance that the value of the investment can go up or down. There is a volatility in the value of investment. So in those cases, you cannot do the business. You cannot do the investment in those business. Those are called the speculative business. Only in the normal safe investment you can do the investment for parking the money. You should not invest in the speculative business. Then you have to utilize for the administrative expense means maximum 20% of the contribution received. That much only you have to spend for the admin expense like staff salary. Those things you have to spend only 20%. If you want to spend more than 20%, go and get the central government approval. After that, you can spend more than 20%. Normal limit is 20%. If you want to do more than that, go and get the central government approval. So the utilization we are talking about a person who has obtained the prior permission or the certificate of registration. After that, the person will receive the foreign contribution. Then that utilization only we are talking here. So these are all the list of the items which will come under the administrative expense like salaries, wages, accounting, legal charges, rent, repairs, other utilities, everything will come under the administrative expense. What will not come under the non-admin expense? For example, you are an organization which is doing research or training. Your main work itself research or training. Then when you are giving a salary for the training staff, or when you are making any expense for the research, for collection of field data, then this is the main activity. So for that, when you are doing any expenditure, it is not an admin expenditure, because your main work itself to do research or the training only. Then, if you are a hospital, you are conducting an hospital when you are giving salary to the doctor, that is not an admin expense. If you are conducting a school, when you are giving salary to the teacher, that is not an admin expense. These are all the main expense. The main expense for the item for which you are running the organization. Then you are having a limit rate up to 20% you can spend the administrative expense. For example, 100 crore foreign contribution you are getting, 20 crore you can spend. This is the limit available to you. But this year you spent only 16 crore. You are having remaining 4 crore to spend limit. Limit is available, but you are not able to spend. So what you can do, you can carry forward this limit. This limit you can carry forward to the immediately succeeding financial year. To the next year, you can carry forward it. So you have to mention the reason also in Form FC4 before doing the carry forward. When you are having the limit remaining, you can carry forward it to the next year, immediately succeeding financial year. Only for 1 year you can carry forward. So that is the administrative expense point that also we have completed now. So as a whole, when you see everything we have completed. And one more thing, here one more point we left out. Here I will show that to you. One example I have skipped there. Here, can foreign contribution be mixed with local receipt? We already saw that separate accounting should be done for foreign contribution and in the local receipt. So you cannot mix it with the local receipt. So this also they can ask you as a question. They cannot be deposited along with the domestic funds. You have to keep it in a separate FCRA account only. So everything you have to do as per this act. All the things we have seen, all the things in this particular act we have completed. Now I will show you one more thing. So all the time limits and then the penalties we are having right in each and every chapter. So for that we are having one index. So that index we can see now. Now these are all the index we are having that we have specially prepared for the IBS purpose. But here it will be helpful for the CTA exam also. This penalty index and then the module 1, module 2 index and then the time limit index. These and all will be helpful for the SPOM Set A exam also. That also I will tell you how. So here when you see the time limit index, here, when you take the time limit index, each and every chapter or each and every act wise, we have given the time limits. For chapter 1, company law, chapter 2, chapter 3, chapter 4, like that, we are having chapter wise time limit. So here if you see Foreign Exchange Management Act, then Foreign Contribution Regulation Act. In this when you see, we are having the study material page number, section number, what is the event, for what we are having the time limit, what is the time limit, everything is given here. Along with the section number and page number, that is the most important point here. In this, all the time limits in this particular chapter will be covered here. Like for suspension, Initially they can do for 180 days, then extension they can do one more 180 days, they can do the suspension, they can extend it. Then when you are getting more than 10 lakh rupees foreign contribution from a relative, you have to give intimation to the central government within 3 months from the date of receipt. That everything have given in the form of time limits, in the form of tables here. Then here when you see, everything is given here, like annual return. Submit annual return form FC4 within 9 months from the closure of the financial year. All the time limits are given here. You can use this for quick revision of the time limits, or before going to the exam, when you want to see the time limits, you can see this particular PDF. It will be helpful for you. And when you are using this for IBS exam also, when you are getting the question from the time limit directly, you can take this particular page. You can take this particular PDF. It is having just a total of 10 pages only. When you are getting a question from time limit, directly you can take this and you can find out the answer. So it will be helpful for you also. Now this is the thing for the time limit index. Then when you see the penalty index, here also in the same manner you are having the penalties, each and every penalty mapped along with the study material page number and then the section number. So here when you see the Foreign Contribution Regulation Act, so these are all the penalties we are having here. For false imprisonment, these penalties we had in a table, right? I had provided you the table also separately for the penalties, whatever the imprisonment, penalty, fine, whatever the things that are there, I have provided you a separate table also. So that thing summarized here. What is the event? What is the penalty? What is the page number? What is the section number? Everything is given here. That also you can use it. When you are getting a question in the IBS exam for penalties, you can directly take this PDF. You can directly take this printout, and it is just 4 pages only. You can find the particular act, take the particular penalty, and you can answer the question. So particularly in SEBI regulations, here we are having a lot of penalties. So in this case, it will be useful for you very well in the IBS exam. When you are preparing for CTA also, you can revise the penalties using this particular PDF. So this and all will be available in the Telegram channel. All these PDF will be available in the Telegram channel. You can join the Telegram channel using the link given in the description and in the pinned comment, and you can access these PDFs. And Module 1 and Module 2 PDF, when you see, these are all specially prepared for the IBS purpose. But you can use this to get an overview of the chapter. Like when you're starting a chapter, you have learned it, but when you're revising it, if you want to see what are all the topics inside the chapter. So now we have completed the entire Foreign Contribution Regulation Act. So here when you see, you will be able to see the points. Here I will show you. This is the Module 1 index. You have to take the Module 2 for the Foreign Contribution and Regulation Act. Here this economic laws we have to take. Here this Foreign Contribution Regulation Act we are having. In this, along with the page number, we have given the section number and what is the subheading. Whatever the subheading that is there in the study material, that subheading will be there. It will give you an idea of what are all the items there in the chapter. Introduction, structure of the act, extent, application, definitions we are having, and then foreign contribution, foreign hospitality. For that, what is the meaning, definition it has been given. Prohibition to accept the foreign contribution, that point we saw. Then procedure to notify an organization of political nature. So that point also we saw. There is a procedure to notify any organization by the central government as an organization of political nature. Then prohibited foreign contribution, prohibition on foreign contribution, exception, where the section 3 will not apply. When you are receiving from relative as a salary, or when you are receiving in the ordinary course of business, or as a part of a gift, as a part of an Indian delegation, then in those cases, the restriction will not apply. Then foreign hospitality, some persons should not receive. Then prohibition to transfer the foreign contribution to another person, that when you are receiving any foreign contribution, you should not transfer it to any other person. Then administrative purpose, that section 8, that point we saw. Then prohibit receipt of foreign contribution in certain cases, section 9, that we saw. Then prohibit the payment of currency received in contribution of that. Like that, when you read this, you will get an idea of what are all the items under the chapter that we have learned. So like this, we can use it for CTA revision purpose also. So these are all the index that are there. I have showed you that you can use this for your preparation for CTA also. This PDF will be available in the Telegram channel. So we have completed the Foreign Contribution Regulation Act. I have told you whatever the relevant points and all the illustrations and examples also you should cover. And wherever we have got questions, what are all the important points, everything I have noted down and given you the points also as a part of the explanation itself. So because of these extra things only, it got a little bit late for completing the session. I initially planned for 1 hour only, but it took a lot of time more than that. So this is the reason, and that's all we have completed this session on the Foreign Contribution Regulation Act. You can like this video if you found it useful, and you can share this to your friends and make a comment on what are your thoughts on this particular video and what is the next topic for which you want the revision video. That you can make the comment. I will see that and try to make the video for that in the upcoming days. So that's all about the session for this particular act.